I want to start by thanking Joan for her lovely introduction and for underwriting the conference, and thank all of you who are here, but especially the participants. We have some participants who have been homeless since September 11th, but are coming to give their papers anyway. We have one person with strep throat. We're not sure if she's going to make it yet. So some people really made real sacrifices to participate. I'm extremely grateful. Let me just say a word about the organization of the conference. The last couple of years, I've been quite privileged to have been invited by Frank to a philosophy colloquium that occurs every year in Prague, and I've enjoyed it so much I've modeled the conference on the Prague conference. Each presenter is going to present their full paper, approximately a half hour, and then we're going to have a half hour for discussion of each paper. So instead of the usual talking heads and everything getting summarized in 15 minutes and 2 questions from the floor, there should be real opportunity for everyone to participate. Probably a few more people should move up to the main table, but please do and feel free to participate. Each paper will be chaired by a person who will be responsible for calling on the questioners to relieve the speaker of the burden of doing so. I'm going to chair Frank's paper. We're going to break at 11 for a coffee break after John Simon's given his paper and reconvene at 11:15 to discuss it. I'm very thrilled that Frank was able to make it. I'm very grateful. Frank Michelman is really one of the 1 or 2 or 3 most impressive academics, intellectuals in the legal academy. Written, by my count, 4 or 5 classic articles, plus an extremely well-received book. He's a Robert Walmsley University professor at Harvard. And I just want to say 2 things about Frank. One, quintessential Frank Michelman, we asked everyone for an abstract. He sent us 6 single-space typed pages. That's his abstract. And the other is just he's a really, really nice guy. Thank you for coming, Frank.
Thank you, Steve. Thanks to Dean Wexler for hosting this event. Thanks to Steve and Larry and in absentia, I guess, Gary, for organizing it. And congratulations to Steve for having provided the occasion in the remarkable and impressive way that he has done so. This is a funny paper in a way, to be leading off an event that's devoted to an examination of Steve's book in the following respect. It's a microscopic focus on about 1 square centimeters worth of a very broad and rich tapestry. And I guess what I want to say is that my microscopic scope on this particular square centimeter is not an expression of the slightest lack of interest on my part or admiration on my part for the rest. It's a terrific achievement, and I will be saying something as I go about some of the dimensions of Steve's work that I'm not really focusing on this paper. What I am focusing on is one particular claim that I draw out of the book. One part of which is reflected in my title. It's the claim that in order for legal decision-making to do the work we expect of law, that's Steve's phrase, legal outcomes don't have to be determinate in the sense of precisely predictable or deducible from known facts and fixed premises. In order for law to operate as law, another phrase I took from the book, we don't have to imagine the legal materials prefiguring uniquely right answers to contested cases. It's enough if legal decision-making is a relatively constrained activity. It can be moderately indeterminate in outcome. meaning that the scope and manner of the moderately indeterminate, relatively constrained, meaning that the scope and manner of the indeterminacy are themselves more or less, which is to say sufficiently regular and predictable. Now, I think before going on, it's that claim that I put under the microscope here. And I think before going on, I want to emphasize that when I've referred in describing the claim to legal outcomes or outcomes of legal decision-making, the reference is particularly to adjudicative outcomes. Clearing in the forest apparently shares with virtually all the rest of jurisprudence the perception that it is at the point of adjudication, the point at which social controversies are submitted for ostensible decision according to law, that the pretensions of legal ordering to do some work or other for society are put to the test. Adjudication is where the rubber meets the road. Adjudication meaning the business of deciding cases according to law, meaning according to what Steve sometimes refers to as the legal materials. Adjudication then meaning adjudicators having resort to such so-called legal rules, standards, and principles as decision according to law may be thought to require. In other words, there's a more or less distinct and distinguishable body of normative propositional stuff, which is legal, in contradistinction to other normative propositional stuff that may be floating around that might or might not be legal. Those are the legal materials. Adjudication is the process of applying them to cases and getting decisions. The idea is that if law fails at that point, then law fails. If there's some unacceptable indeterminacy at that point, then law is indeterminate in a way that defeats its performance of the work we expect of law. Now, when Steve claims that that expectation is not defeated by moderate indeterminacy or by merely relative constraint, I take him to be meaning to defuse a racking, obsessive debate that has been going on amongst legal theorists, maybe since the beginning of legal time, but certainly virtually throughout my professional life. It's the indeterminacy debate, right? On the one hand, just to put it in ridiculous terms, on the one hand you have people saying the judge can do anything, and therefore law doesn't do anything. If the judge can do anything, then law doesn't do any work. And on the other hand, you have an old guard defending the proposition that the judge can't do anything, that legal decision-making is more or less tightly constrained and determinate, so law can do work. Now that debate has mainly been conducted in terms of conversation about what language can and cannot do, and partly in terms of what culture does. The objects of analysis in this debate, insofar as there have been objects of analysis, have been language and culture. Steve, armed with cognitive science, not Steve alone, George, others, say, there's more, not that the lingual or grammatical dimension is not important or the cultural dimension is not important, but there are other dimensions here, and the most obvious of the additional dimensions is, if I can put it this way, biology. There's a biological dimension here. And I think it is fair to say that Steve makes a a good deal out of a fourth dimension, that is to say, the dimension of persuasion or rhetoric. There's a rhetorical dimension. So here's the idea. Legal decision-making at the point of adjudication is done by a select body of public officers whom we call judges. Not everybody gets to be a judge in a society like ours. From the very fact that somebody has attained to high judicial office, you may be able to draw some kind of inference about where that person stands on sort of the spectrum between the mainstream and outliers in terms of cultural and normative disposition within the distribution of a society's population. And furthermore, these officers are multiple, and they engage amongst themselves in what Steve calls processes of persuasion. And furthermore, they do so conscious that they're in front of an audience in the same way that the people around this table engaged in processes of persuasion will be aware that we're among an audience. And for various reasons, they're concerned that people should regard the results they reach as at least within bounds of plausibility, as not off the map, or as we like to say, off the wall. So now, if you put all this together, what language can and cannot do, what culture can and cannot do, what biology does do, and what happens when people like judges in adjudicative settings engage in interjudicial processes of persuasion, being conscious of a societal audience looking on. Putting all of that together, and this is what I mean when I speak of Steve's book as a tapestry, because he weaves in and out amongst all these dimensions. Putting all of that together, Steve arrives at a point at which he's prepared to turn and face each side of the obsessive debate that I was talking about, and say to the skeptics, the trashers, you're right, adjudication is indeterminate. It would have to be. But it's only moderately indeterminate, and the scope and character of the indeterminacies are within certain limits knowable and predictable. And they are knowable and predictable to a point that is sufficient in order for law to do the work we expect of law. So you're right and you're wrong. Bottom line, wrong, insofar as you want to say law can't do anything. And then Steve will turn around and say to anxious liberal jurisprudence, a company in which I probably, I do count myself, he'll say basically, it's indeterminate. But don't worry. It's relatively constrained, and there's sufficient constraint, although there is indeterminacy. You don't have to squeeze out all indeterminacy in order to establish, right, that's what he wants to say to us. You don't have to squeeze out every last element of indeterminacy in order to defend the proposition that law can do the work we expect of law. And that's what I mean when I say Steve's intervening in this debate in a way that's meant to diffuse it. There's a consolatory message being delivered by cognitive science to anxious liberal jurisprudence, and Steve's the messenger. Okay? And I want to say, I'm sitting here and I want to say, well, I don't know. And let me tell you why I don't know. You know, in order to know whether I'm to be consoled here, I have to know whether Steve and I both have the same idea of what is the work we expect of law. That's where the gremlin may be. So I made a little crude list of the work we expect of law. And I got 3 items on my list. It's a 3-word list: stability, settlement, legitimation. Okay? We rely on law to provide a relatively stable transactional context, believed necessary for rational and efficient planning of affairs and projects involving the actions and interests of multiple persons. Stabilization, coordination. Coordination goes with stability. Settlement. Law is meant to provide people with a relatively peaceful, decisive, and unbloody way to get specific, eruptive social controversies resolved so that life can go on, and in a manner that the participants, the parties to the controversy, will be able to accept. Okay. Legitimation. I want to put that one aside for a second, except to say that as I'm going to explain the notion of the legitimation function of law, it differs from the first two in the following respect. It may depend on the content of the answers judges reach, not only on the predictability of the answers judges reach, or on their having the character of being within the outer bounds of fair play in our society, such that I, as a party to this controversy, would not be justified in walking away and feeling that the judge had stolen it from me, right? The settlement function is satisfied as long as the parties can have the impression that the judges have done an honest job, even if the case comes out differently from the way some lawyer advised it might. For the settlement and stability functions to be performed, it's not crucial that the judicial answer be right. It's not crucial that it have any particular content. So, some play in the joints. Something short of perfect predictability, as long as there's substantial predictability, and as long as the range of variation away from the predictable center isn't too great, needn't undermine the stability and coordination function, and it needn't undermine the settlement function. My question is whether anything short of getting the right answer can perform the legitimation function. And I think it's a serious question. Now I point out that Steve does not address this question at all in the book. In fact, Steve never gives a list even as perspicuous as the one I gave of what he understands to be the work we expect of law. I think that's true. If it's not, that's expected. So I'm left, to speculate about what he's talking about here. And because he doesn't ever address the legitimation function, which it seems to me is in the problematic state here I've tried to describe, I am left having to speculate about what Steve, right? I think that Steve means the stability, coordination, and settlement functions, and I think that that's what his argument is addressed to. I think he's left the legitimation function unaddressed. And because I obsess over the legitimation function, I don't actually obsess over the settlement and stabilization functions much. I obsess over the legitimation function. So I don't know whether, I should take the comfort Steve's offered, because in the existing posture of affairs about the book's actual content that I've tried to describe to you, I'm left guessing what Steve understands and would say about the legitimation function. He could mean, he could be implying, insinuating one of three things. And I'm flashing back here to some prior discussions that Steve and I have had about other matters. He can say, legitimation, legitimation, who cares, forget about it. It's not important. It's not important, so it's not a part of the work we expect of law. Or he could mean it is important, but it's so far beyond the capacity of law to do for us that it's not a part of the work we expect of law. That is, it's not work that any sensible person who understands how law works, how body works, how culture works, how language works, could possibly think law could do for us. So it's not a part of the work we expect of law, important though it may be. The third possibility, which is intriguing, but which I'm not putting most of my marbles on, His esteemed response would be to say, it is important and law can do it, and my book contains the makings, although I haven't elaborated them here, contains the makings of a showing that law can do it. That's the positive, the possible positive response. Okay, now I need to talk to you more about the legitimation. I think I'm about halfway through my time.
Yeah, you're doing all right.
Another 15 minutes?
Yeah, take a few minutes.
Okay. I think what I need to do is put on the table the idea of positive legal ordering. So, positive legal ordering is an effective social practice in which most inhabitants of a territory stand ready most of the time to comply with norms of conduct pronounced to be law by socially recognized officials. And furthermore, to support the use of social force if necessary to secure compliance in general with those norms. On grounds that I believe to be no less Hobbesian than they maybe are also Kantian, liberals accept the moral necessity of positive legal ordering. Basically, the idea is that virtually any world in which any positive legal order exists is better than any possible world in which it doesn't. Because the worlds in which it doesn't are worlds in which life is going to be solitary, poor, nasty, brutish, and short. So positive legal ordering is on the table. But it's dangerous. Because there are an infinite number of positive legal orders. And, you know, an infinite number of what John Rawls would call basic structures of society with their legal dimensions. And each one of these has a different set of payoffs for different groups of people in the society. In other words, it's always possible to move from one positive legal order to another positive legal order and make someone who's relatively poorly off or feels relatively poorly off in the first feel better off in the second. Or to put it another way, law is force. Political government in a system of positive legal ordering is implicit or explicit force, and you need a justification for the exertion of force against people who don't agree to the laws that are made, and maybe feel that very, very vital interests of theirs are being infringed by some of the laws that are made. The question of legitimation is the question of, you know, how we justify this practice of bossing each other around this way. And the liberal answer is positive legal ordering is justified when it is conducted in accordance with law. When there is a rule of law. Where rule of law does not only imply certain kinds of procedural regularity and procedural decency, but where rule of law has a substantive content. It implies that all of positive legal ordering is conducted under, let us say, a constitution that constrains it, that safeguards certain basic human interests or human rights as they're conceived to be from incursion by positive legal orderers, that ensures to each inhabitant of a positive legal order certain kinds of participation, certain kinds of voice, certain kinds of influence, certain kinds of ability to affect outcomes, right? So there are participatory assurances, and there are human rights assurances. And the idea is that given the general benefits of positive legal ordering, and even allowing for the dangers to particular interests of positive legal ordering, as long as it's conducted according to law, that is to say, according to the dictates of a proper constitution, it's okay. We can have the benefits and we can justify the force. Right. So the term law here means not only the outcomes of positive legal ordering, It means the set of pre-understood terms and limits under which positive legal ordering is conducted. And lawyers in societies with written constitutions tend to locate that higher law in the Constitution. Now that means that constitutional interpretation becomes a matter of crucial importance to the question of legitimation. And it seems to mean that if constitutional interpretation is indeterminate in the sense that we are unable to tell in some sense, that it remains obscure, that judges are getting the interpretations right, we have a legitimation problem. And I believe that it's that perception that causes liberals to obsess, or at least is part of the explanation of why liberals obsess over indeterminacy. Now, there isn't any doubt that there's a lot of indeterminacy in constitutional legal interpretation. We have agreement on very high-level abstract propositions, like any constitution that could serve the legitimation function for law at that level that I've been trying to describe would contain a term that absolutely guaranteed, say, equal liberty of conscience to every person. And our Constitution contains language that looks in that direction. And there's a certain narrow range of questions that arise under that language that we can pretty much be sure we know how judges are going to decide. If some legislature makes a law that attacks a particular religious profession as such, or that disadvantages religion as such, or does something like that, it's going to be unconstitutional. But suppose some positive lawmaking body makes public health laws, and it makes zoning laws, and then it makes another law saying that a church doesn't have to obey them, or a church affiliate doesn't have to obey them. There are controversies of that kind sprouting up all over this country now, and they cause a great deal of consternation and agitation among the parties to them. And the answer, right, there's a question that arises at the level of constitutional law. Are exemptions of this kind constitutionally required by the constitutional principle of equal liberty of conscience? Are they prohibited by the constitutional principle of equal liberty of conscience? Is it unreasonable to say they're required? Is it unreasonable to say they're prohibited? Are there people in the society with legitimate interests, perfectly understandable human interests, who would be in a position to say, if the higher law does not contain a guarantee of exemption from a public health or a zoning law for a church, then how do you expect me to sign on to it? As a person willing to accept what other outcomes it turned, the lawmakers generate under this Constitution, if I don't have that kind of protection for my religious faith, and you've got another constituency that says, unless special favors for religion are prohibited, I don't know how you reasonably can expect me to sign on to this. Right? Now, there's a third possibility. The Constitution doesn't answer the question. The question of religious exemption is meant to you leave it to ordinary positive legal ordering. You leave it to politics. But I put it to you that there are constituencies out there who will say, unless this question is settled this way or unless it's settled that way, I can't sign on. Right? Now, what does the political liberal theorist do at this point? I'm telescoping, complicated argument, but and I have in mind John Rawls here in particular. What the liberal political theorist does is to say, well, what we have is these central ranges of applications of the basic human rights guarantees in the Constitution, that is, laws punishing people for a particular religious profession are unconstitutional. But these guaranteed central ranges, what he calls constitutional essentials, don't cover much. If anybody's been reading Mark Tushnet's ideas about the thin Constitution, you'll hear the resonance here, right? The Constitution prohibits some infringements on freedom of speech, and we know that every judge will enforce them. But if flag-burning laws were upheld, the world wouldn't come to an end, and that's outside the thin Constitution, right? So this business about religious exemption is outside the thin Constitution. Affirmative action, its permissibility under this, that, or the other set of circumstances is outside the thin Constitution. The question whether money talks, in other words, Buckley versus Vallejo, is outside the thin Constitution. All these things are up for grabs in politics, right? Because there's reasonable disagreement about them. But the Rawlsian liberal doesn't give up at this point. The Rawlsian liberal now puts on the table the idea of what he calls the constraint of public reason. Positive legal ordering will be sufficiently governed by law. I'm translating. Will be sufficiently governed by law to be legitimate, as long as we can have the assurance that the people who make the constitutional interpretative decisions are doing so in the right spirit. That is to say, are asking the right question. Where the right question would be something extremely abstract, like which interpretation would be more conducive to the realization in present society under present circumstances of the principle of mutual and reciprocal recognition by each participant of each other as a free and equal person with a life of his or her own to live in accordance with his or her own reasonably adopted lives, or something like that. Now the claim is that if issues like the religious exemption issue are submitted to a process of decision in which the spirit is the right spirit, which the right question is being posed, that we can tolerate variant answers to the question given the assurance that the people addressed the question in the right framework and the right spirit. And at some point, this has to land on a substantive foundation. That is to say, there has to be some claim that you're prepared to stand up for and defend about what the right spirit is. Now, what I want to know, right, suppose the right spirit were the spirit of making the Constitution be one that could reasonably be agreed upon by people who reciprocally recognize one another as free and equal, or something like that. And you take Steve's 4 dimensions: language, culture, biology, persuasion, rhetoric. And we understand that the people who are making the decisions are people who have been able to attain to high judicial office in a society of this kind that selects judges in the way we do. What I guess the question is, would you be interested in the question? Would you be interested in the question whether the 4 dimensions generate a sufficiently confident prediction that the question would be addressed in the right spirit, or that it would be framed in the right way to perform this last-ditch legitimation function for obsessing liberals in the way that I've tried to describe. And I'll stop.
Kind of left it, I have to answer the question. Am I interested in the question? Yes. Do I think that you'll like the answer? No.
I'm curious, what kind of question, liking or not liking it, I can take any answer you give.
Let me see if I can keep my comments brief so that other people can jump in. Let's start with the public reason constraint, which is the question you put to me. You asked the question, given what we know about how minds work and how the process of persuasion works, can we rely that, and I take this example not at random, the Scalias of the world, will decide these questions in the right spirit? It seems to me, both as an obvious empirical matter and as a theoretical matter, the answer is going to be no. Which is why I think that it's a mistake to obsess about that question. Let me put it to you this way. There's something about liberalism that's very attractive. Although I'm not sure I want to really say that I'm in the same company as Mark Tushnet in how we approach the Constitution, but he thinks he's a liberal. Last I talked with him, that's his current claim. And I don't really kind of...
I've accused him of it.
Yeah. Well, he's, at least in semi-private, he's admitted it. And I'm not sure that I would characterize myself that way. But what I find attractive about liberalism, and let's call this the Hobbesian insight, right, is its recognition of the diversity and intractability of human nature, and an effort to seek to corral that, to minimize it, to make life a little longer, a little less nasty, a little less brutish, mostly through devices of formal equality and procedural justice. And that's obviously an attractive goal, an attractive end. But liberalism has this other, what I find problematic about it is liberalism has this other moment, and we can call this one the Kantian moment. When it relies on formal equality and procedural justice to corral what I call the diversity and tractability of human nature, it assumes that the people who are going to be doing that are all these rational, reasonable people. And it seems to me that those two insights are very much in contradiction of each other. It's a split personality, right? At one moment, the notion that would have to be you almost have an Aristotelian notion, right? Of some people, hopefully, would have the telos to be chosen to be the leaders, will be the rational, reasonable ones, but everybody else, right? It's a war of all, would be a war of all against all. So I think that picture is a hopeless one. It's not one that can provide the solution to the right kind of problem, the right kind of solution to the problem that I think it correctly recognizes. So I wanted to backtrack and say one more thing, and then throw it open. Is go through your three characterizations of what I might be saying, and I think that although being not an all or nothing kind of person, my answer is a little of each, although not all in the same degree. The first is, you say Steve might be implying that the legitimation function is a false demand, something we were mistaken ever to have worried about. Well, I think it is, in a sense, a false demand, in the sense that obviously it's entirely hypothetical, right? It's put in the original position, social contract form, and the fact of the matter is that none of us are ever really in a position to decide whether to sign on or not. We're always already thrust into some ongoing situation with some ongoing set of parameters, framework, legal framework, and we don't really ever get to sign on or agree to, right, to withhold our consent or grant our consent. And in the end, right, it's just a matter of degree. I know the question. I'm not denying the question of the legitimacy of the use of force, but it's always a question of which parts of the system we think are appropriate and proper and agree with, and which parts we think are unjustified. And we're different. It will always be a different mix. So it's always going to be much more of a realistic, socially situated, pragmatic choice rather than a theoretical, behind the veil of ignorance choice. I don't think that it's something we're mistaken to ever have worried about, because the question of force and the legitimate use of force is a pressing moral question. So that's the part I think I certainly agree with. Second negative message, you might be implying nothing about the demand's importance, but only something about law's inability to handle it. Sure, legitimation matters. It's not part of the work we expect of law, or at any rate, what we ought to expect of law if you understand how it works. That's, I think, pretty close to my real position. That's basically right. That we need to have a better understanding of what it is that law really can and can't do. It can do the settlement, as you say, I think you read me correctly, the stability and settlement functions work relatively well, even with degrees of indeterminacy, but it's never going to be able to carry off the legitimation function at the level that you would like to carry it off. But I don't want to assent to this one 100%. It's not exactly what I'm saying, because if that were true, then the next one would have to be zero. I don't think the next one's zero either. The next one's small, maybe about 20%. The third possibility, the constructive one, maybe Steve stands ready to include legitimation within the work we rightly expect of law and to uphold against Frank's instinct, proposition that merely relative constraint is enough to make adjudication work and able to perform a legitimation function. Here's the part I want to give you. As I see the argument of the book, and one of the reasons for the title, is here's the kind of groundwork you would need to have the law do the things you want it to do. If you understand how law operates, then you can start to think more realistically about how it can do the things you would like it to do. Right? And if legitimation is one, then you have to understand something about the social, psychological, cultural, material bases of rational argument and rational agreement before you could think about reasonably think about, in a productive way, constructing a society that could have enough relative unanimity that law could do the legitimation function you want it to do. But you would have to start at a different place, at a different level, doing the groundwork of building a society in which that would be possible. Now, for those who haven't read the book yet, to try and put some flesh on those bones, in a nutshell, the argument is the legal rules will work when there's a relative stability and relative unanimity in social practices, and because the ideations that arise from those practices will converge because they're grounded in the same practices. But when you have great diversity within a society, right, and we live in a very pluralistic society, obviously, then the areas where social practices diverge, values will diverge. You're not going to be able to get that unanimity. You won't be able to get agreed upon interpretations of the Constitution and the legitimation that you want. So to turn it around on the other way around, I think Merleau-Ponty said it best. I'm not going to paraphrase because I don't have the exact quote at hand, that it's only in a relatively wealthy, relatively well-organized society that something like a real democracy is actually possible. An insight, of course, that dates to the classical republicanism of the Greeks, and something that you, Frank, have written much about. But it's at the level of those social practices, I'm thinking back now to your welfare rights article, right, that we'd have to begin the work of democracy if you really wanted to take the legitimation function seriously. So that's my answer. Questions? Bailey.
Most interpreters of Kant see it as a even though we got strong scientists and forms of categorical material, it's still a function. And yet we think of it as a legitimate moral system as well. So why do you think there must be substantive aspects to the legal system to make it legitimate if the moral system need not have that?
Well, that question gets to the distinction between substance and procedure, and on which side of the line, if you think there's a line. I'm going to become Winter-esque here and say I don't want to be antinomially captured by the substance procedure distinction. What happens is, and I've really written about this. There's a sense in which the liberal solution to the legitimacy problem is a procedural solution. That is to say, the Constitution taken as a whole is a procedure relative to the concrete controversies that politics resolves according to the procedure laid down by the Constitution. I'm about to relativize the substance procedure distinction. But a part of that constitutional procedure is a set of what we all feel are substantive guarantees about equality before the law, freedoms of speech, association, religion, from cruel and unusual punishment, from enslavement, etc. So on one level, those are substantive guarantees, but they are incorporated into the procedural framework that we call the Constitution, to which we refer for procedural resolution the issues that we can't agree on unanimously in society. So we can't agree on what to do about affirmative action, but we say we'll let constitutional procedure settle it, where a part of the procedure is the Equal Protection Clause. Okay? In that sense, Kantianism surely is a procedural theory. This is the sense in which Jürgen Habermas can claim to be giving a proceduralist theory of democracy. How far up the level, how far up the level of abstraction can we go in proceduralizing? We have a disagreement about how to apply the Equal Protection Clause in affirmative action cases, let's say. So what we do is we extract some higher level norm. Not equal protection of the laws, but something like equality of concern and respect. Or, now we're up to the Kantian level, reciprocal recognition of one another as free and equal agents, or free and equal individual moral agents. All right? Is that a procedural principle? Well, from one perspective, it is. From the perspective of the attempt to resolve all the lower lying controversial questions, that's a procedural principle. But from another perspective, the proposition of mutual and reciprocal recognition of one another as free and equal moral agents is a highly substantive principle. That is to say, it's not a principle that you would expect every human being on earth who reflects on the matter to accept. It's a particular view of right and wrong. It's a particular view of the human condition that's controverted. It's the Kantian view of the human condition, and in that respect, it's full of substance. So I don't, I'm fighting the hypothetical. I'm rejecting the proposition that Kantian moral theory is, purely and simply a procedural theory. It depends on where you're looking at it from above or from below.
Just a brief follow-up on that. I agree entirely. Mark Johnson and I have a study of the metaphorical structure of Kantian moral theory in Philosophy in the Flesh. When you go through that in detail, you can see exactly why Kantian moral theory is so nutty. It has four crazy metaphors put together, and also Kantian moral theory contradicts most of the results in cognitive science. It presupposes that there's a transcendent human reason. That's one thing. And it isn't. I mean, it just goes against all the results that we learned from cognitive science. So, if you start with Kantian moral theory, you're going to get an answer that goes against the way people work. And I think that's also true of Rawls, to the extent that Rawls is applied Kantian.
Daniel? Yeah.
The other way of putting these things about is that actually, in many cases, it's not just a gender opinion, it's actually both. So that the ability of a system, of a legal system, to provide not settlement, but unsettlement and not stability, but destabilization, could be part of this with other requirements for legitimation in a particular political circumstance, which is the event, the civil rights movement. If the civil rights movement had been able to use the courts to unsettle and destabilize, the legal system as a whole would have been more legitimate and not as many people have those. Then vice versa, and we've seen many cases like that. So that these functions are actually, again, in particular, historical junctures, actually, the demands are actually to be opposed. They're kind of, I would say, expect a nod in the perspective, but I wonder how then it relates to this loss on competitive. What does it do with the project of laying out conditions for this vision of work?
Yeah. Okay, Nathaniel, you'll have to test out whether I'm getting the full force of the question by trying to give a response, because sure, the demands for stability and settlement may very well, in a particular setting, be working at odds with the demand for legitimation, depending on how we construe the latter. And civil rights movement looks like a great example. We might think that a political order, including its positive legal order, that didn't leave space for that eruption, but that didn't affirmatively accommodate it and, guarantee, as it were, space for it, would be lacking in legitimacy in the normative or the moral sense that I have in mind. But I don't see how that observation in itself, you say you're jumbling them up. If by that you mean that we don't have an unadulterated demand for stability or an unadulterated demand for settlement, for decisiveness, but that those two are themselves torn in some way, then I don't know whether I'm ready to go along with that. It seems to me that, the usual way of thinking about these matters is stability is desirable, not absolute negative entropy, not minus 273 degrees centigrade, where everything's a solid crystal and no atoms are moving. But stability is a practical prerequisite for a decent life, and settlement is a practical prerequisite for a decent life, and there are sort of minimum levels of those that we have to insist on. Those are the work, part of the work we expect of law. We also want legitimacy, and maybe that means that the minimum levels of these other two that we'll insist on aren't absolute zero, but we'll still be insisting on the minimum levels. It still seems to me then a reasonable interpretation of Steve's consolatory claim that it's directed to the settlement and stabilization functions and is somehow or other deflected from the legitimation function, even though I entirely agree that if law is performing this legitimation function, that the other two that I mentioned are going to have to be in some degree compromised. That is, I think that what you've said is an interesting and important observation about the relationships that subsist among my three categories. I just don't see how it interferes with my gloss on Steve's book.
I guess, Nathaniel, it matters how you take Frank's three categories. I don't want to own them as my categories, but I took Frank's notion of settlement not to be settlement versus unsettlement, right, but a process of dealing with disputes, right? So the civil rights movement.
Get rid of them as they come.
So you resolve them in some peaceful, non-bloody way as they come up. Yep. So civil rights movement is an example, but it's not a counterexample. It's an example of settlement, right? It resolves it through the legal process, although the interesting part is, of course, the extra-legal process. Yeah. That's not strongly a counterexample. On stability, I think stability is somewhat of a misnomer, and stability is, if you want to use that term, it has to be a dynamic stability, because you're talking about obviously a very large, very complex social system. So it has to be a dynamic system that's overall stable because it reaches homeostatic states. But that's not stability. I took also the import of Frank. So stability here is, in the book, it's my position, to the extent I have one on this, would be, I agree with Llewellyn's concept of legal certainty, which describes legal certainty as this ongoing, always changing thing because it's a social dynamic, rather than as a static set of rules with answers. So then that also is comfortable with the notion of destabilization, of change over time. Sure.
But I guess my perspective is very skeptical in relationship to the transcendental pattern of and that's the example they were trying to get at. Right. And you could say that in the long run, the civil rights movement or any movement for gaining social participation on settlement, but that moment would be a very long run. At the end of that run, things would be so fundamentally different. State settlement is really somewhat of a stretching of that term. Anyway, I just wanted to put on the table the skeptical about transcendental patterns.
Can I say a brief word in response to
Sure.
Your this will be very, very brief, I think. I just want to, this is by way of positioning myself vis-a-vis the political liberal legitimation project that I was describing. Because my own position with regard to it is complicated at the moment. I'm sympathetic. That is to say, I want this effort to succeed, and I think it's important. But the more I work on it, the more doubtful I become about whether it can work. And my doubt actually is concentrated at the level at which I turn to Steve and say, can you help me with this? That is to say, whether there's anything, whether you're forced by recognition of reasonable disagreement at the level of interpretation of constitutional principles into the public reason. That's sort of the last defense, right? That they're going to be decided according to the right spirit. And then you got to have agreement of some kind on what the right spirit is, or that project fails too. That everything is just dissolving at some point. In other words, that if you're not going to renege on what Rawls calls the fact of reasonable pluralism, if you're going to take it really seriously, that you can't get this kind of legitimation by hypothetical agreement. But that's now brings me to the thing I wanted to state, Steve. This approach does not presuppose that people actually are reasonable and rational. It sets up a hypothesis about what, it asks what it is that reasonable and rational people could agree to. And then if it weren't true that legal decisions in a society were being made in accordance with the constraint of public reason, there would be no way to defend the legitimacy of the use of political and legal force in that society. And he's just reaching, at that point, he can be reaching a negative conclusion. He will say there is no legitimacy. But Rawls isn't up to that in the end, and so he says, he actually argues that it could be true. And he actually says things like, taking men as they are and laws as they ought to be. Given the actual history of constitutional democratic countries combined with reasonable psychological and sociological speculation, we actually could believe that this constraint exists. And it's at that point, it's in that turn of Rawls's argument that I look in Steve's direction and say, can you possibly go along with this? Given the cultural conditioning of the history of constitutional democratic societies, given the biology, given the discursive constraints and all the rest of it, could it be that a constraint of this kind empirically exists? Because at some point I understand Rawls to be making the empirical claim, not just putting forward the critical standard. And I'm in doubt. And that's what I guess I want to communicate. I'm not a convinced fellow traveler in this project. I'm just a wishful one.
One more question. Okay. Larry, then.
I'd like to also ask Frank about the relationship among his three categories, but this time from the personal psychology of the judge. And let's say a judge has a case that he or she has to decide, and it's a difficult decision. You said earlier that parties don't want to feel that that the court stole it from them, and I think that's right. But not only do we know that as legal scholars, but judges know that. And in deciding a dispute, a difficult dispute, there are two things they can do. One of them is to say, well, I'm going to do the best I can using values that I think that everyone or most people would respect from a legal system. And you don't have to worry too much for a few reasons. One of them is that I don't have to do this all the time. That's the business of having some level of determinacy, enough determinacy. And the other reason is that the reason I have this job is because I was trusted to do my best, and I promise you I'm doing that, and that's all I can give you. There's another move the judge can take, which is the one that they usually do, that is reason for pessimism, and that is to say, I'm going to make a decision, one of you is going to win, the other's going to lose, and it's not my fault. And that's the typical judicial move, and the formalistic move that we see so much with Scalia, it's very popular. It's popular and overt now. But it's always been popular among judges. And somehow we have to get out of that. We have to have decision makers not being ashamed of indeterminacy and engaging in cynical moves to hide it. So we have continuing decisions on constitutional and statutory issues by the high courts based on fights over which dictionary to use and just absolute nonsense for important decisions for a society to make. I guess my feeling about whether to be optimistic or pessimistic about the endeavor that Steve is encouraging is how likely is it to get those making decisions to be willing to say, well, this is really who we are and as well as we can do, and you're better off knowing that somebody heard you than you are with these kinds of cynical moves.
Well, it's as much a question for Steve as it is for me. So first of all, I'm in complete and total sympathy with the normative drift of your comment, Larry. I think we would be much better off with honest than with obfuscatory judges. I think our population of judges is split on this matter, and I think that they're not only split externally, that is to say, as among themselves, but they're sometimes split internally. You cite Scalia as an instance of the judge who says, I didn't do it, the law did it. He does sometimes take that posture, but I mean, if the contrast is with the judge who consciously says, I'm trying to conform my decision with a set of values that I think has resonance in the society, take a look at Scalia writing his dissents in the VMI case or in Romer versus Evans, and you'll see a Scalia of just that very kind. So there is some lack of stability, I think, probably in the characterization of any real real life flesh and blood judge there. But in any event, I suppose the question is a question of whether it's possible to move the judiciary in the direction of the style that you favor and that I would favor by social cultural pressure that works itself out through judicial selection procedures, through, and just through the kinds of environmental social pressure that the society is capable of exerting on any group of public officials.
When you were talking, Larry, what I was thinking about was Frank's testimony at the Bork, I think it was at the Bork hearings.
No, I didn't testify.
Which was,
was
one of them. Thomas.
I don't know what they said.
Well, I mean, maybe I have it's something you said, maybe I have the venue wrong. Distinguishing between judges who saw things sort of always clearly and rigidly, and judges who understood that.
Thomas.
Yeah, it was at the Thomas hearing. And my reaction is, I think I actually disagree with the last point, frankly. I don't think that most judges are split. I just think there are very few of the latter kind of judges, who are truly pragmatist judges. When I try and think of who they are, not a lot of names jump to mind. One that jumps to mind would be Posner some of the time, but only some of the time. When I talk later today, I'll take him on his election book for being very Scalia-like in his approach to the law. I think the VMI is not a good example of Scalia certainly being of the
Rhetoric. See, rhetoric.
But the rhetoric is of social values. But he's absolutely certain about what those social values are, and that he's got the one true take on those social values. I mean, and that opinion, more than some of his others, is reeking with that kind of moral certainty. So that's not the kind of judge that you were describing at the hearings. Aware that these things are open-ended, that difficult choices have to be made, that can't necessarily be in a rigorous or formal way justified. I'm not sure what it would take to change the culture of judges to that. I suspect that it would take a significant sea change in our expectations of law and our concept of law before the judges would be willing to go out on that limb. I think it's only a very confident judge like Posner who feels comfortable enough to say, hey, I could go this way or I could go that way, and actually say that in the opinion, which, as I said, he does only some of the time. I think we have time for one more question.
This is actually, Steve, for you on your response to Frank's categories. Perhaps I've gotten it wrong as to what Frank means by legitimation, or perhaps I've gotten it wrong as to how you responded to him. But here's what perplexed me. One of the things I thought was really elegant in your book was how you could say, well, there's a whole bunch of stuff that looks like it's outside the system, but it's not. This is this very interesting artifact in which we need to feel that it's there. It's actually within the system, but that's okay because it's constrained enough that we're not really kidding ourselves by acting like, not constrained enough. The social meanings will get us where we would have hoped the constraint would have gotten us, because we're all coming from the same social meanings and so on. I thought that was very elegant and very true. And I guess what I'm wondering is why don't you do a bit more of that kind of analytic move when it comes to a concept like legitimacy, which, to the extent I understand, it seems to me a similar sort of thing. That is to say, something that's in theory outside the system, something that we want to experience as being outside the system. But ultimately, as you convincingly argue in the book, we don't really have access to stuff that's outside the system.
Well, no, I think you read it exactly right. And to that extent, I guess my answer to you is I think I do. And that was implicit in what I think I said earlier, and that is that to the extent, right, I mean, the chief argument here, I guess, in the book will be Chapter 8 on rules. And that rules will work to the extent that the rules itself crystallize or internalize the social practices that they purport, but only purport to regulate. And to that extent, the rule will not only work, but it will seem legitimate. So that, I mean, that's where it's in that discussion, in the Llewellyn discussion. But then the question is, what the liberal wants, what Frank wants, certainly what Rawls wants, is how do you justify as legitimate a legal system under conditions of very substantial pluralism, right? Where we don't actually all share the same practices and consequently the same values. And that describes, of course, large chunks of modern life, but no one can deny that. And there I turn to Frank and say what Frank also correctly read, that law can't do that.
When you need legitimation most, your system is
not going to function. And so it would be nice to have it in some theoretical sense, but it's not available to we mere mortals on Earth. I think if there are no more questions, we'll move on to Jonathan's paper, and then we'll run to about 10 after 11 and take a break.
You want it now? Take it now. For him. He has both a JD and a PhD from Berkeley, and he's the author of a book called Poor Discipline, and he's also the co-editor with Tom Baker, which was published by the University of Chicago Press in 1993. He's also the co-editor of a book with Tom Baker that's coming out, again by the University of Chicago Press, called Embracing Risk, Transforming the Culture of Insurance and Responsibility. And he just finished yet another book manuscript, something easy to do when you have young children, I'm sure, called Governing Through Crime, Criminal Justice and the Recasting of American Governance, 1965 to 2000. The title of his talk is Governing Through Crime Metaphors, so look forward to hearing the talk.
Thank you. First, I want to say how grateful I am to Brooklyn Law School and to Larry, Gary, and Steve for inviting me here. I knew that it was going to be an opportunity to have a lot of intellectual fun with some high-powered folks. It's also, since September 11th, a very deeply moving experience for me to be here. It's my first time in New York since that event. I grew up in Chicago, and I've always been a fiercely proud defender of that city's sort of second city status. When the Sears Tower was built and it was taller than the WTC, it meant a lot to me at 13. But when I was 15, my parents, in a surprise Hanukkah present, gave me a ticket on the Amtrak version of the 20th Century Limited and a phone number of a friend in the village to stay with. And since then, over the years, I've come back to New York again and again, and I won't bore you with the details of my own personal sort of Bildungsroman of New York, but the city has always smelled like adulthood to me. And I don't know whether the terrorists attacked freedom or democracy, but they certainly attacked a place that, unlike about 90% of America, feels like home to me whenever I'm here. So it's really good to be back. As someone working on what I would describe as a decidedly post-social science research agenda, and I want to distinguish that from methods, which I think is a different discussion, I come to cognitive science with two impulses. First, to be highly skeptical of the normal science posture of the field. And here I would just note that, sort of like my former discipline of political science, cognitive science has the misfortune of sort of begging its scientific status every time it mentions its name. But it clearly is a normal science in its self-conception. But my second impulse is to simply steal as many of its very considerable insights as I can. And what I'm essentially going to do in the time I have is to in a sense, treat this weekend as sort of a cognitive science basketball clinic for law professors. And I'm going to, try to go to the basket a few times and let George and Steve correct me when I'm done. The recent work I want to talk about does come from my book manuscript, Governing Through Crime, in which I argue that in a variety of ways, criminal justice has become, in a sense, a metaphor for government. Really, it's a metonymy and a metaphor, I suppose. In a sense, criminal law, one level of this is that criminal law, to pick up already on some of the cognitive science language I'm going to try to play with here, criminal law is an ICM, an idealized cognitive model for law itself in popular consciousness. When people think about law, they tend to think of the criminal law as the model of how law works. But to me, even more interesting is the way that political leaders, especially executive leaders over the last generation, have really recast themselves as law enforcement and recast their opponents as either pro-criminal or just criminal. A recent example, and there are many, is our new Minister for Homeland Security, or whatever they're calling this, Governor Tom Ridge. I mean, if you just take a quick look at his profile, and in my book I have a whole chapter called The Prosecutor's Two Bodies, where I sort of just take a bunch of politicians in both parties and just walk you through the way they've created their cultural capital as politicians, and it's just drenched with crime. So that Ridge, even though he's a Vietnam veteran, trained at Harvard Law School, he was first elected governor in a campaign, and I'm reading here some commentary by Steve Rosenfeld that was on the tompaine.com website for attribution purposes. He says that Ridge was first elected governor in a campaign that used political ads modeled on the Willie Horton ads by then candidate George Bush's supporters in 1988. His first gubernatorial campaign focused on criminal justice reform. He capitalized on the tragic case of Reginald McFadden, a commuted murderer who went on a killing spree in New York shortly after his release. His Democratic opponent had voted for McFadden's release, thus the Willie Horton ads. Ridge also made juvenile justice a theme of his campaign. He urged that all juveniles, not just those accused of murder, be tried as adults and do adult time. After his campaign, he immediately called a legislative session that focused entirely on crime. A flurry of bills were enacted, including a Megan's Law bill, a three strikes bill, a bill revising the Pardons Board. He stepped up the war on drugs, limited parole. And this is a very typical profile. I think in my research, I think that the figure who sort of starts this off, very ironically in some ways, is Bobby Kennedy, who as Attorney General first merges a sort of presidential posture and a law enforcer posture, his treatment of the Hoffa case being an obvious window into this. If you want to see a really interesting sort of latter-day working out of that possibility in Kennedy's politics, look at Kathleen Kennedy Townshend, his daughter and a frequently mentioned Democratic presidential candidate. If you visit her webpage, you'll see that being a lieutenant governor, she doesn't really have a job, so she's defined herself as Maryland's crime czar. The police answer to her, the prisons answer to her. Her whole shtick is values education, oriented toward crime. Everything is about crime, and if you visit her webpage, you'll get the drift. And there are many, many other examples. Now, in his deeply insightful recent book, Moral Politics, pioneer cognitive scientist George Lakoff takes crime discourse as one of the clearest examples of his claim that underlying conservative politics is a metaphor of the family with a stern disciplinary father as its leader. And as I've tried to rethink much of my book and the empirical research in it through that lens, it works with tremendous power. If you take the stern father image and try to think about why criminal law is so important, you notice a number of things. First, it exemplifies the Stern father's fundamental claim to power that without him there'll be an inevitable pull toward chaos and violence. Second, the substantive rules of criminal law, as I've already mentioned with respect to popular culture, tend to exemplify the idea of simple commands, the thou shalt nots, that form most people's ICM of law. Third, of course, crime invokes punishment, and not simply in the Durkheimian sense that it produces a common emotional response, but that it gives us really an occasion to bring out the metaphors of punishment, prisons, execution chambers, things of this nature. Now, I want to, in a sense, suggest that this is a brilliant analysis which allows you to make a lot of sense of the form in which most of crime politics takes shape. Everything from three strikes as a kind of a weird metaphor for to use in law, but one that works in terms of the strict rule model that we've talked about, all the way from that to the great reluctance of legislators all over the South and in my home state, currently home state of Florida, to abandon the electric chair. Not just the death penalty, which is, God forbid, but I mean, even the electric chair and the chair itself is an important metaphor. Now, all I want to suggest at this point is that although we can get a lot of work out of the cognitive science model, it raises a lot of problems for me too. For instance, how did liberals and conservatives come to espouse crime so intensely, right? It's clearly fits with both the Stern father and in many ways the nurturant parent, which is the liberal model for Lakoff. And you can see how much our own current crime politics have both in them. The fear of drugs affecting kids is very much a nurturant parent impulse in part. But after all, Margaret Thatcher led a conservative revolution in England, much like Ronald Reagan's, without emphasizing crime. Indeed, it wasn't until his troubled second campaign that John Major turned to political consultants linked to the first Bush administration, not a very good idea at that point, and adopted a tough-on-crime approach. Likewise, liberals during the progressive era turned to criminal justice as their preferred mode of addressing all kinds of social problems, and you get the juvenile court and lots of other action on that front. Now, I share Lakoff's reluctance to trace to trace liberalism or conservatism primarily to political theory, and I agree with him that we should take seriously metaphors and popular culture and culture generally. But I would suggest, and this will give you a sense of how I'm going to come at both the Winter and Lakoff projects, that in doing that, we have to constantly bring into the picture the social policies and the consequences that have shaped the lived experience of those political subjects, right? So would conservative working class voters, the so-called Reagan Democrats, like those in Macomb County, Michigan famously, have prioritized the strict father in their political choices if the successes of the liberal New Deal social policies had not helped them finance the move from high-density urban neighborhoods tied to mass transit and expensive social services to gated communities and places where they can easily thumb their nose at the need to spend money since it's already been spent for them. Would liberals emphasize the nurturant parent if militarism and nationalism had not produced after the Civil War new kinds of political subjects, vulnerable soldiers, freedmen, and others? Now, let me turn to my crime story before I have some further issues that I could pick with, or problems I could try to raise for Lakoff's model of the crime takeoff in a sense as a picture of conservative triumph, because I think it's more complicated than that. But I think what I really want to do is not disagree with the model so much as to move to a position that I take to be sort of in between the purely literary use of metaphor that we see in so much writing, and then the conceptual use of metaphor that Lakoff and Winter both have used to great effect in their work. And it's what I want to describe as essentially governmental metaphors, metaphors that we govern through. And so their function isn't just to communicate, but to govern. Now consider the Holmes free trade and ideas metaphor in Abrams that Winter uses brilliantly, I think, in the chapter on that in his book. In the majority opinion that Holmes had written somewhat earlier in Shank, Holmes had endorsed a far less protective standard for subversive speech, analogizing it to falsely shouting fire in a crowded theater. Now, this is a very powerful example for Winter because you can really see that there are two metaphors here and that they do a lot of the work that the doctrine is supposed to do. But what's striking to me is that Steve makes the point, well, what makes Holmes's free trade and ideas metaphor sort of possible is the rise of the market and the transformation of society to a place where markets are very familiar social practices. The problem for Winter is that Shank comes down in an era just as saturated with markets as Abrams. That is, any time in the 200 years between the Milton quote that he uses and Abrams, you would think that we could arrive at this insight. So why has it happened now? I would go back to the metaphors and suggest if you look at these metaphors, they're rather striking how much of a role crime really plays, right? I mean, the Shank metaphor, falsely yelling fire in a crowded theater, would almost certainly have been treated as a serious crime. And at that time, especially when deadly fires in such places were a very common tragedy, perhaps even murder if deaths occurred. And moreover, the whole image of falsely yelling fire in a crowded theater could almost be a hornbook example of what in criminal law we call abandoned and malignant heart liability, a kind of mental state often considered morally the same as an intentional desire to hurt other people. When we look at the Abrams metaphor, what we see is, of course, the market. And so, to me, part of the shift from one to the other is not simply the availability of the market, which is there in Shank as well, but in a sense the withdrawal of crime as the predominant way to see speech and to govern generally. Now, to consider a recent example, drugs. I mean, it'd be easy, and one could easily, and people do, public policy figures do make the case that drugs is really a market phenomena. Let's manage it as a market and government regulate it as a market phenomena. And yet, for a variety of reasons, the notion of it as deeply crime is so strong that despite the fact that we're in an age that is very much engaged in valorizing markets, it doesn't seem to work. It doesn't push the other metaphor out of the way. Well, let me turn to two larger examples that I'll try to spin out for you a little bit, and so we can have some material on the table. The first is a notion of a crime metaphor as it operates at the heart of the state, in Congress, in the presidency, in our national government. And I want to look here at the Safe Streets Act of 1968, which introduced the image safe streets, the metaphor of safe streets, again, I think a kind of metonymy for cities, safe streets, and I think marked the beginning of the era of governing through crime in which we now live. And at the heart of this, and I don't have time to go into great detail on the way the statute does this, but where it takes us ultimately is to the crime victim as a kind of dominant, what I in my book call an idealized political subject, but here I could call it an idealized cognitive model in some ways, of the citizen, right? And not the first time we've had this in our history, but only the most recent of a long chain of such idealized figures, the yeoman farmer, the freed slave, the industrial worker, the biologically vulnerable consumer, at various times have played a decisive role, not simply in mobilizing political support, but in showing people in government how to govern. What are the problems that need governing? What are the forms of government that are legitimate to address those problems with? And it's with the Safe Streets Act that we begin to see the rise of the victim in this. Let me just give you to get a feel for how the victim operates today, let me just give you a brief quote from our former Attorney General, Janet Reno, speaking to a meeting of victims' rights advocates. But most of our recent Attorney Generals could have made the same speech. In the speech, she says at the dramatic point in it, quote, "I draw most of my strength from victims, for they represent America to me. People who will not be put down, people who will not be defeated, people who will rise again and again for what is right. You are my heroes and heroines. You are but little lower than the angels." Now notice that you could easily substitute the words yeoman farmer, freedman, industrial worker in there without any strain at all. Now, the Safe Streets Act is interesting in two regards. First, it's the foundation for our current government through crime regime, I believe. And secondly, in many ways, it was initiated by liberals in an effort to head off a conservative shift that they saw going on. And in the book, I try to look at it on three levels. First, as a solidifying political victory for a new governing coalition in America, the start of a new spiral of power and knowledge, interventions about crime, criminals, and victims, but also law enforcement agencies, courts, correctional agencies, and also as defining a new set of privileged subjects for government, including victims and state law enforcement, especially noteworthy. Now, I'm not going to analyze the statute in any details. I really want to talk, and we can talk about it in questions period if people want to get into what's in the statute, but I want to talk about the politics around it, and the metaphor I'm going to analyze comes from LBJ's speech when he signed it. Contemporary observers in the 60s saw the rise of the crime issue as a clear and significant challenge to the liberal domination of domestic policy in that period. Johnson intuitively understood how dangerous violent crime was to the post-New Deal coalition he was seeking to maintain. Goldwater had invoked crime in the streets in his 1964 nomination acceptance speech, and LBJ had trounced him in the election by focusing on his own, on Goldwater's extremism rather than democratic permissiveness. But he immediately recognized the threat and appointed Nick Katzenbach to head up a commission, a national crime commission that would, he thought, allow a liberal approach to crime to develop. There were other kinds of forces at work, however, besides Johnson's effort to give this a liberal cast. Richard Nixon, gearing up for his presidential run, was making crime a dominant issue in the '68 campaign, and probably most dramatically of all, Governor Wallace, trying to move away from his segregationist forever stand, had seen crime correctly as the issue on which he could go to the north. And in fact, in '72, when he won the Michigan Democratic primary, it was a triumph for that kind of view that crime can become a new unifying theme for a whole conservative coalition in America. It's ironic in many ways that the law was given its final form in the days following the assassination of Senator Robert Kennedy, who by then had actually moved into a rather anti-criminalization mode and had become the Senate's leading force against the Safe Streets Act. And he was particularly rejected both the wiretapping and the attack on the Supreme Court in those acts. But as soon as he was killed by a gun in a violent crime in Los Angeles, it finished any resistance to the law by seeming to embody exactly the problem that the law seemed to be willing to address. To its liberal critics, once the law was passed, it represented a moment of inherently reactionary regression. British journalist Richard Harris, writing in The New Yorker at the time, described it bluntly as, quote, a piece of demagoguery devised out of malevolence and enacted in hysteria. But it's not hard to see from LBJ's point of view why this was a crucial step. He had been, LBJ was a student in the sense of FDR, and the one thing he understood was that once America becomes concerned about a problem, you have to look like you're trying to solve that problem, even if you keep failing. It was okay for FDR to keep failing to solve the Depression as long as he seriously was trying to solve that. And of course, for LBJ, he could see that the Democratic coalition, rooted in the great urban cities like New York and Philadelphia, Chicago, and LA, was directly endangered by violent street crime. It was splitting the black and white sides of that coalition. It was breaking up the kind of power base that had elected Democratic presidents for half a century. I want to focus briefly then on the speech that Johnson gave. It's a very interesting moment. He waited, the law was passed on June 6th. Johnson waited till the very last day that he could sign the law before which it would become an act without his signature. And he gave a speech that was widely quoted, and the central line in the speech, when he explained why, even though he had grave doubts about the law, he was going to sign it, he said he hoped that the new law would, quote, help lift the stain of crime and the shadow of fear from the streets of our communities. All right, so the stain of crime, the shadow of fear, the streets of our communities. Those are the sort of metaphors I want to focus on for a moment here. Take the stain of crime. It's actually a very complex metaphor as I read it here. First of all, the source image is the image of a physical change in the appearance of something highly visible on a person, usually their clothing or the skin itself. And it's moving that onto crime, right? So one meaning of stain is often associated with the discoloration of a piece of skin or clothing by substances that usually have an anthropological pollution sort of meaning. So it could be spilled foods, blood, mucus, urine, or excrement in babies or in people that have to handle babies a lot. It also has a very different meaning when we talk about staining wood, for instance, where we darken the surface of a thing. And my colleague Don Jones, tomorrow, I suspect, will talk a lot about the darkening metaphors. And indeed, this is part of a larger system of light-dark metaphors that runs all over the place. Now, shadow of fear has somewhat the same structure. Fear does not literally cast a shadow. The metaphor is another variant of the light-dark system in which positive attributes are light, negative ones are dark. Fear darkens one's sentiments, one's prospects, one's countenance, almost anything. Now, I think what's interesting, first of all, the stain metaphor, right? You might think that this is a kind of classical moral notion that criminality besmirches the person who performs it and rises as a sign on them of their own moral darkening. And yet when we look at it in the whole image, it's more complicated. The shadow metaphor, which is part of this same larger metaphoric system that Johnson uses in this line, it shows a person who's darkened by fear not shamed by it, right? So we really have sort of, and I view this in a sense as Johnson speaking to what he sees to be the two parts of the Democratic coalition that are being endangered by crime. One is the black community, which I think he sees as being stained by crime. So at a time when civil rights is a major agenda for reshaping America, violent crime is morally downcasting blacks, giving whites an excuse not to take their moral claims seriously and to revalorize their own desire for segregation as a morally appropriate desire. The fear and the shadow of fear is for the white city residents who are fleeing the city to the suburbs and leaving the Democratic Party for the Republican Party. Now, what's interesting is that the image, when you look at it fully, the stain of crime doesn't appear on the person or the shadow of fear on a person. It's on the street that both of those things are actually transposed. And of course, the street here, I think, is a metonymy for cities. And it's an interesting one because on the one level, it distinguishes cities, the great dense urban centers, which of course by 1968 were losing population and feeling problematized in all kinds of ways. And it essentially distinguishes them from what's a new thing, the suburbs that in a sense don't have streets, cul-de-sacs, gated communities, but part of it is a flight from streets. And of course the street becomes street crime, street music. I mean, street becomes simply a metaphor for, or a metonymy for urbanness. So I see Johnson's metaphor as expressing a very complicated political strategy for the shifting, in a sense, terrain, the urban geography of the Democratic Party. And it does two things. I mean, it expresses this whole fear complex that's going to be associated with cities. But it's also going to foreshadow a new governance strategy that's going to focus on streets. So the Giuliani moment of wiping homeless people off the streets, et cetera, is really already there. It's already prepared for by the late 60s with the focus on fighting for the streets. And also in a much more technical way, our whole urban governance model gets reshaped. If you go look at cities that were rebuilt after riots in the 60s, like Detroit, go take a look at Rosa Parks Boulevard in Detroit, which was actually 12th Street for the riot, which was the hub of the black commercial district. It was rebuilt as a broad Haussmannian boulevard designed for fire trucks and police cars and promenades, but not for complex urban life. And ironically, that model, if you go to the suburbs now, and that's what their transportation takes place on. I mean, you have to drive through those corridors to get to malls and other enclosed spaces of urban life. Now, in retrospect, the Safe Streets Act was a signal event that marked the end of the Great Society era and of the liberal pro-civil rights dominance of federal policy. It would rapidly produce its own political theorists and political scientists in the form of Richard Scammons and Ben Wattenberg, who published the book The Real Majority in 1969, only a year after the act. The book used crime as the central example of how the Democratic Party was in danger of losing its two-generation-long majority status by ignoring the profound shift of its traditional supporters on a host of social issues, but of which crime was the most important. Now, the big lie since then is that it wasn't until Clinton that the Democrats actually embraced the war on crime. In fact, with remarkable speed, the Democrats in Congress followed the advice of Scammons and Wattenberg. Nixon, in his first year or two in office, introduced crime bill after crime bill. The Democrats delayed on them because they didn't want him to be credited with them, but when the 70 election rolled along, they instantly passed a massive crime bill that included the no-knock entry provision and the preventive detention proposals that had been considered too extreme for the Safe Streets Act in '68, but we're now, and just to get a flavor for how much discourse had changed, here's a speech which has a lot of weird resonances now after September 11th, but this is a speech from, a line from a campaign speech that Edward Kennedy gave in his first re-election bid in 1970 to an audience at Boston University. Quote, "Those who seek change by the threat of use of force must be identified and isolated and subjected to the sanctions of the criminal law. They are the hijackers of the university, and like hijackers, they must be deterred and repudiated. Any person who lends them aid and comfort, any person who grants them sympathy and support must share the burden of guilt." That's Edward Kennedy in 1970. Now, I want to quickly shift over, even though I have more to say about that, to a different example. And how am I doing time-wise?
5 minutes.
5 minutes? I was afraid of that. Okay.
Take 10 if you want. There's time.
Let me just give you a quick feel for, because as a sort of Foucauldian, for lack of a better theoretical identifier, when I talk about government, I don't want to think mainly about, or only about the state, or at least the central embodiments of the state. I want to think of a much more diffuse and kind of governance that takes place in institutions. So let me switch to crime as a metaphor in the workplace. And I have a chapter in my book called Penalty Box, which looks at this. Now, crime has always been part of the messy struggle for control of the production process, right? At the rise of the factory system in the 18th century, folks like E.P. Thompson and Doug Hay have shown us how much of a role crime played in redefining traditional forms of non-wage compensation for employment, like taking time off, taking surplus materials home for private use, became crimes, and a whole criminal justice system had to come into place to deal with that. American history also includes numerous examples. On the one hand, the rise of contract at will represented rejection of an earlier kind of punishment model of how to govern employees with the whip. On the other hand, of course, the rise of unions immediately occasioned the crime metaphor. Unions were treated as criminal conspiracies by the state courts in the late 19th and early 20th century. At the very same time, New York businesses pioneered the use of turning to organized crime to break up unions, which ironically led to unions to develop their own alliances with organized crime. And ironically, today we often think of unions as somehow a synonym for organized crime. But in the heyday of collective bargaining from the 30s through the 80s in the United States, I would argue that's a time when criminal law, at least in the workplace, was going down as a metaphor. Because unions had been legalized, and strikes could take place, giving you a form of grievance procedure, a way of taking your struggle with management out into the open that didn't risk being labeled criminal and being criminalized. And indeed, labor scholars in the 60s wrote openly about the decline of dismissal as a sanction in the workplace and analogized it to the end of capital punishment, that we were seeing a sort of shift to rehabilitation both in the workplace and the prison. Now, the familiar curve of penal severity from the late 1960s to the present begins to look a lot like the opposite decline of union membership if you flip the chart over. The unionized portion of the workforce had entered a period of free fall in the 60s, from which it may now be recovering, if it is at all, only now be recovering, if it is at all. And I think we see as organized collective bargaining ceases to be the predominant paradigm for conflict resolution in the workplace, the resumption of crime as the dominant metaphor. So what do we see in the workplace today? A new emphasis on surveillance and detection of illegal behavior as a predominant way to make decisions about people. Fraud has become a pervasive obsession, really, with all large information and financial services companies. And in all workplaces, there is a heightened concern about violent crime, concern that leads to more efforts at surveillance. Ironically, crime is also returning, I think, as a nexus of employee resistance to management. And once again, it takes multiple forms. I would argue that in some respects, and this isn't without controversy, that the rise of essentially civil rights claims in the workplace for workers who can get access to them is a way of defining the boss's behavior as at least immoral, if not illegal, and therefore framing it in a more crime-like way. A very different kind of resistance is marked by the widely publicized pattern of armed assaults by current or former employees directed against co-workers and especially managerial employees. Many of these are a response to dismissal or discipline. And a strikingly high proportion of these incidents involve white males, a group singularly cut off from most of the predominant civil rights remedies in the workplace. I don't want to quite set up a sort of alternative, go to court or go postal, but there's at least a pattern there that I want to note. And indeed, the imperative of preventing assaults at work has become one of the dominant, I wouldn't say the only, but one of the dominant governing obsessions in most workplaces today. Let me just give you a little feel for this by turning quickly to one interesting employment law case that I thought really gives you a picture of this. It's Cody versus Cigna Healthcare of St. Louis, 1998 decision by the 8th Circuit. There it involved a claim under the ADA. Carol Cody, the plaintiff, worked as a nurse for the defendant, a health insurer. Her job required her to make on-site quality of care reviews at physicians' offices in the metropolitan St. Louis area. Cody claimed to suffer from depression and acute anxiety, a condition that was worsened in her view by having to go into certain areas of St. Louis that she considered dangerous. Her supervisor refused to help, and according to Cody, intentionally assigned her to such areas. Cody attempted to take her dispute to the executive director of Cigna's St. Louis office, notifying him of her concerns and the fact that she was under treatment. The director set up a meeting for the next day. According to Cody, when her supervisor learned of the meeting, she warned that Cody would, quote, suffer the consequences for having complained. Cody found a styrofoam cup on her desk with a sign attached reading, quote, alms for the sick, unquote. When she complained about that to the director, she was urged to take the day off, and the meeting was delayed. That day, a variety of negative reports about Cody began to flow to the director. A call from a coworker reported that Cody had been behaving strangely and mentioned carrying a gun. The next morning at a meeting, other employees complained to the director that Cody behaved bizarrely, including sprinkling salt outside her cubicle to keep away evil spirits, as well as staring into space and drawing pictures that appeared to observers to be of sperm. There were further gun images. Then Cody actually called the director during this meeting. During the call, during the meeting, the director actually stopped to take a call from Cigna's Human Resources Department. During this call, Cody actually arrived at the director's office and was advised, and Human Services was advised by one of the employees that she had, quote, a bulge in her purse. Human Resources then contacted Cigna's security department, who sent a, quote, local security specialist who was introduced to Cody as a mediator. He advised the director to deactivate Cody's security access card and conducted searches of the purses of both Cody and the supervisor. No weapons were found. Human Resources advised the director to offer Cody a paid leave of absence, followed by return to work only if she passed a psychiatric screen. The director presented this option to Cody, rejecting a proposal he had earlier suggested of just switching her to another supervisor. Cody apparently accepted the terms until this happened. Now, this is the final scene in the story. As Cody was leaving the meeting and the building, she was unable to access either the exit from the building or the parking lot because of the decision to deactivate her card. She was permitted to leave by a security guard who, upon instructions from the director, confiscated the card. Apparently angered by these rituals of mistrust, Cody then brought the suit. That was actually what precipitated the suit. Now, I won't take much time with this, but I think if you look at Cody versus Cigna, not as a story about the legal doctrine governing the ADA, but as a picture of the way crime works in the workplace on multiple levels for multiple players, right? So first consider Cody herself. She invoked her psychological distress at being in areas she considered high crime parts of St. Louis in her efforts to exercise more control over her own work conditions. We don't have enough information to make full sense of this part of the story. Is Carol Cody white? Were the areas she considered high crime parts of St. Louis heavily African American? Did her distress at being in those areas overlap in any way with the preference for not dealing with physicians and medical staff who were African Americans? We simply don't know that. But we can also take a look at the picture here of the other employees. We cannot tell from the facts and the opinion why Cody's fellow workers sided with the supervisor rather than her. At any rate, the flow of calls to the director and the emergency meeting that was held the next morning in Cody's absence to discuss her peculiarities in more detail speak volumes about the power that the right kind of fear of crime claim makes in the workplace. It's one thing to say, I don't want to go out to this medical clinic in downtown St. Louis, then you get ignored. But if your claim is that this coworker may be bearing a gun and may go postal, you get a very different kind of response. We also get a picture of the vast apparatus of security that now dominates not only businesses but buildings all over cities, right? The rituals of having your card accepted or rejected by a door, not a bank machine, but just a door, a parking lot exit, et cetera, is now ones that we've all internalized and come to accept in many respects. Let me just close. Crime governs America today as one of its dominant metaphors of how to govern, what problems need solving, what solutions are appropriate. Critical criminology and critical legal studies, I think, have largely failed to recognize the metaphoric power of crime in organizing our expectations of government. And I don't think the current obsession with crime can be either confronted or overcome merely by talking about real crime statistics or victimization statistics, or even doing the kind of ideological critique of crime legislation. I'm afraid that the events of September 11th are likely to both hide the metaphors of crime behind somewhat less troubling ones politically and drive them deeper into our experience of life and our ways of imagining governance. I want to close by suggesting that you can't beat a metaphor without a metaphor. To the metaphor of crime, I offer or re-offer the metaphor of cancer. In 1971, you may recall Richard Nixon launched two wars, a war on drugs and a war on cancer. The war on cancer really didn't go anywhere. It created some funding for research, but it didn't become a major political initiative. The war on drugs may be the most important political transformation in the last quarter century in America. Now, I could offer lots of reasons why I think drugs beat out cancer. Part of it had to do with the age that the boomers were at. And in the 80s, I see the boomers, being young parents at that point, as being much more obsessed with crime than they were a little bit earlier. And now that their kids are growing up, they're getting older, their parents are dying, they're worried about dying, I think cancer might have a better chance. I could go into this in some length in the questions if people are interested in it. I think cancer would actually be a much more productive metaphor for government than crime. It would point us to the environment, it would point us to business, it would point all the reasons it didn't take off in 1971, because it would have gored so many more oxes than a focus on crime has done, which all the negatives went to the cities, minorities, disempowered groups. I'm going to stop there.
Susan?
identification with the victim is very crucial to this whole story. But part of the irony is that the 60s, right when Warren was writing Miranda, was sort of the high point of, for at least some people, of identifying with criminals. So George Jackson's book, Soledad Brother, could be a bestseller, a couple years later. And, Carol Chessman had begun the 60s by sort of inventing the con writer, or reinventing the con writer as a very important political figure, right? He gets executed, but the governor's weeping when he, can't stop the execution. And it's a tremendous moment of where people are invited not just to say criminals may be deviant others who we ought to integrate rather than despise, which is sort of the classic 20th century approach, but really to say, and Foucault himself is a part of this in a sense, what part of the criminal really lurks in me? What part of me really shares the excitement, the transgressiveness of crime, right? Part of what happens after that is it becomes just morally unacceptable to even explore those issues, right? So that, a classic example is, what happens to Norman Mailer when he gets that prisoner whose name I'm forgetting at the moment, Jack Abbott, out, and his whole, I mean, one could do a whole analysis of his backstepping from that, that position for certain kinds of liberal intellectuals. And it's become very difficult to even talk about what's going on in prisons or what makes criminals in just a criminological positivist sense, because you appear to be giving too much moral validity. And indeed, I'd say one of the reasons we as a country support things like the death penalty is it's one of the few penalties that can't be mistaken in any way for accepting any kind of identification with the criminal. Even the prison is accused of ultimately being complicit with the prisoner because we have to get along in this box. But when you execute somebody, you can treat them as a complete animal up to the point at which you exterminate them. And indeed, that whole story of how we change our thinking about the subjectivity of criminals is one of the challenges, in a sense, I would put to George's model of crime in the moral story. Because after all, take three famous 20th century criminals, Nathan Leopold, Carol Chessman, Ted Bundy. They all are perfect fodder for the stern father. I mean, they're young men who give into their impulses, commit horrible violent acts. And yet they end up standing for very different things in the 20th century. Nathan Leopold, being defended by Clarence Darrow, becomes sort of the embodiment of the rehabilitated con. He becomes educated, he was already educated, he becomes a kind of social worker in prison, etc. Carol Chessman became the embodiment of that, the con as transgressive, other, hip author. And of course, Ted Bundy is pure evil, which fits better, more comfortably with the conservative stern father. But in a sense, I think part of my problem with the pure cognitive model is it doesn't take into account that kind of historical shift in the meaning of these particular characters. One last thing I would say is I think social science is very important, and part of what I do in the chapter on the Safe Streets Act, the reason the Safe Streets Act is so important, you won't find much rhetoric in there about victims. What you will find is the funding for what became the endless study of victimization in America. In other words, we began to create victimization as a more visible target for government than crime was, in a sense. We know more about victimization than we do about crime. We have loops and pathways of knowledge in the government and in state governments, linking them to federal money, tied with the victim. And so it becomes I think, kind of a power knowledge takeoff, in a sense, even though when you start with the 68 Act, there's not a lot of rhetoric. By the time you get to the 94 Crime Act, it's this paean to the victim as kind of a saint, a modern-day saint. But thank you.
Gary.
I had couple of questions. One was about your comment about how criminal law was on the decline during the collective bargaining period of the 50s and the 60s. Well, actually, at the same time, the law of secondary boycott was turning to criminal metaphors in identifying a very powerful and important weapon that unions were using to strengthen the right to strike. And the crime metaphor was used significantly at that time. And at the same time, this leads me to the other question, which was wondering about this alternative metaphor that you're holding up, this idea of the cancer metaphor. It was exactly at that time that many of the decision makers in this law of secondary boycott were looking to the legislative history where the cancer metaphor was used to justify the prescription of secondary boycotts. It was spreading disease in the body politic and all of that. So I wonder about whether they're really separate, whether the metaphors actually reinforce each other in powerful ways. And the other thing is, in thinking of cancer, of course, the book that comes to my mind is Susan Sontag and How Metaphors Kill. And that leads me back to the significance of the crime metaphor. So I see it collapsing at various levels.
Those are both really helpful comments. I mean, I have to be careful with the workplace story, because it's one of the exciting things about writing this book is it kind of forced me to just learn a lot about areas that I don't know that much about. And I'm sure the story about the workplace is very complicated, and I want to look at this secondary boycott issue because, indeed, maybe by valorizing a certain kind of conflict as non-criminal, you also create on the margins the possibility of enforcing those boundaries with crime, of course. Just briefly on the cancer thing, I have a chapter in the book which I think gets to some of the complexity you're talking about. And it's an interesting story because, of course, the phrase zero tolerance, which is today one of the great slogans of governing through crime, begins its life as a comment on the Delaney Amendment. It's all about cancer in the food supply. The first popular author that I have found that uses zero tolerance is Rachel Carson in Silent Spring, when she says the minimum we ought to demand from government is a zero tolerance policy toward cancer. Then it gets hijacked literally in the early Reagan administration as a crime metaphor, and it becomes so thoroughly embedded that in the 1988 campaign, George Bush can actually say on the stump, we ought to turn the same zero tolerance we have toward people who put drugs in our school to those that pump pollution in our rivers, not noting that it had actually come up the other way. Now, what's interesting to me is when you look at it, not just the transposition of the metaphor, and I'm not sure if I'm right in describing zero tolerance as a metaphor, but we can get back to that, but is how it works as a governance strategy. In the Delaney Amendment context, what zero tolerance is about is like a strict liability rule designed to influence corporate decision making. It's not about stigmatizing, punishing, excluding. When you get to the zero tolerance in the war on drugs, it's all about stigmatizing, isolating, and excluding. It's all focused on individuals. It's all on people at the bottom of the hierarchy, not at the top of the hierarchy. So, yes, and cancer, as Sontag shows, is available for so many different kinds of agendas. And America has been obsessed with it. There's a very good book on our sort of century-and-a-half long obsession with cancer, much more intense than the Europeans. We've seen it as a kind of quintessential challenge. And again, it's a question of what are the things you want to emphasize in it. The things I find intriguing about cancer, again, as a metaphor for risk that government needs to tackle, is precisely the things that point away from the individual, the environment, the workplace. In the 50s, the biggest issue around cancer was toxins in the workplace. It became one of the first real openings to attack workplace pollution, which had been really non-problematic in the World War II era, when we were just glad to have people working and licking the radium paintbrushes as they put the dials on the bombers and whatnot. By the 50s, cancer became the avenue for making that conduct deeply problematic. So if we can take cancer in the right way, as I said, you can't fight a metaphor without a metaphor. So I'm open to better suggestions. Steve, you're in charge. Oh, no, Larry, you're in charge.
Yes. Luke?
What you said was very interesting about cancer pointing away from the individual. And I think what Professor Herman said about the importance of the victimization attaching to a particular individual. It seems if you're going to fight a metaphor with a metaphor, you really want something that is personal. And cancer, you can personalize it if you have a relative who is, felled by the mighty disease of cancer. But as far as, what cancer itself is, it's renegade cells mutating in strange ways that are very unhealthy. So it seems like, I don't dispute the need for a better metaphor, but I don't know that cancer is the one. But also, just a quick other thing, the metaphor of criminalization has in some sense, it seems, been reappropriated by popular culture. You saw it first sort of in rap music. All of a sudden, crime was glorified. And it was being glorified in popular cinema, since before Scarface and after that, but it was always